Tonight we have two presenters. We have Deborah, wait Deborah, with over 25 years of legal and business experience. Deborah is a seasoned litigator. Deborah has been handling community association covenant enforcement for over 15 years. She was previously a deputy district attorney for 10 years. Her specific thoughts on practicing in the community association area: while it is amazing how often I think there is nothing new under the sun, homeowners continue to amaze me at the lengths they will go to get their way. As a litigator, the fact that I have spent the last 25 years trying to get people to comply with rules and statutes comes in very handy. We also have Amanda. Wave, Amanda. Amanda began her career working as a criminal defense attorney. She then advocated for persons with HIV and AIDS at Vivint Health, a nonprofit organization, where she practiced in a variety of areas, including employment discrimination, social security, disability benefits, bankruptcy, and estate planning. Amazingly enough, she discovered she loved better-side bankruptcy law and continued working in that area until moving back home to Colorado, where she then opted to use her experience to assist community associations. Amanda's knowledge and skills range from the courtroom to the boardroom, and her well-rounded legal background allows her to address the needs of our clients. She is licensed in Colorado and Wisconsin, as well as the District of Colorado and the Eastern and Western Districts of Wisconsin. When she isn't working, you will most likely find her reading a good book by a warm fire or spending time with her family. With that, give a warm welcome to our presenters. And we'll
Can you make sure the doors are unlocked? Thanks. And I'm not sure the
All right. Can you hear me okay?
Yes.
Woo, HOAs. I'll try not to set the speaker off with that annoying sound, but I probably will, so brace yourself. Okay, so today I'm going to be talking about two of your favorite topics and mine, collection and foreclosures. They're not actually anybody's favorite, but here we go. So as you may have heard, we had some big changes with the legislature last year in the form of House Bill 221137, and that went into effect last August. And it has kind of revamped how we can pursue collections and also affects foreclosures. Some of the big parts of it are that this bill required us to update collection, covenant enforcement, and conduct of meetings policies. And the law was very specific, stating that the association cannot take legal action unless it has those policies, the updated policies in place. So even if you said, wow, we've done everything we were supposed to under our old collection policy, if you don't have that revised one as of August 9th, you're kind of just at a dead stop until you did. There's additional notice requirements to it. You now have to post to people's doors. I can tell you no one is a fan of that, although we have seen an uptick in payments. And you have to send it certified mail in addition to one other method, which we'll get to later on. It also is limiting interest to 8%. So even if your declaration says 21%, for example, it's now 8% moving forward as of August 9th of 2022. It changed application of payments. If you remember what that is, it used to be that you could have a policy that said that money that came in the door went first to legal fees and costs, and then to fines, and then to late fees and interest, and then finally to assessment. And this has redone it, so now it goes to assessments first. This bill also allows owners to designate a contact that you will have to correspond with as an association. So if I come in and I say I'm living down the road and I want Deborah to be my designated contact, which I'm sure she would volunteer for. You can see the excitement on her face. You would have to, as an association, send all of the notices you're sending to me to my designated contact. And I get to choose, if I would like, a preferred language to have those notices in. Not necessarily Klingon. So if I'm the owner and I say, I would like all of my correspondence in, I think we had one that was Mandarin, then the association would have to translate all of those notices into that language. And then the final thing under this one, I say final, it's final for purposes of this evening, is that everyone who has a delinquency, even if it's $1.24 in interest, is now required to have a delinquency notice sent to them every month until they're back to a zero balance, regardless of whether they're with legal already, or they're with a collection agency, or you said, hey, you only have $1 left, and they said, I'm not going to pay it, you still have to send that notice out. Now, here's the caveat with this. Some of our owners are already either A, in legal for collection, or B, in bankruptcy. So then you have to be very careful, and there's very specific language you want to add to the notices, particularly for someone who's in bankruptcy, so that they know you're not attempting to collect a debt and violate the bankruptcy stay, but that rather you're trying to comply with state law and it's just for informational purposes. Okay. You guys ready for the next one? Okay. All right, so there's more changes. This has to do with the payment plan letter. So previously, payment plans, you were required to offer a 6-month repayment plan to owners who had a delinquent balance. Now it has to be 18 months. The minimum can be $25 a month. You cannot mandate that it be higher than that, although an owner could certainly acquiesce to entering into a payment plan higher than that. It has to be equal payments over 18 months, or if they do the $25 a month and they owe $12,000, that's obviously not going to get paid in 18 months, so then you would have something else like a balloon payment in month 18 or something to that effect. Here's the problem. If the owner enters into this payment plan for 18 months, they're perhaps going to default. You cannot turn them over to legal until they've defaulted at least 3 times. It doesn't have to be in a row, just 3 times. But the payment has to be at least 15 days late. So if I'm only 5 days late on my payment, that doesn't count. The $25 a month is just for the delinquent balance. The owner still has to keep up on the assessments. Now, why $25 a month? Because in order to foreclose, the foreclosure part of HB 22-1137 says that you have to offer this 18-month payment plan letter and the $25 a month. Again, if I come to you as an owner and I say, well, I want to pay $150 plus assessments, that's fine. But you cannot go, hey, owner, you're going to pay $150 a month plus assessments. Because the owner is allowed to choose the amount down to $25. Previously, if you remember, you had to vote to turn over a file for foreclosure. The board would have to get together, you'd have to have a vote, either record it in the minutes or fill out the form. What has changed about this bill is that you now have to do that for each collection action as well. And it has to be in an executive session meeting. So previously we would have a lot of associations who they kind of get a rundown of here's all our delinquencies, okay great, send them over to legal. So now you have to go through them one by one and say the owner at 1625 or the account number 1625, who votes in favor of turning over, who doesn't, record it in meeting minutes, or sign a resolution, and then you'll send all of that over to it. And then of course you have to document everything. Everything. It requires you to document every contact with the owner, every attempted contact. I'm going to tell you that if you're going to post this as required on the property, I would take a picture or have your process server take a picture with a date stamp so that you can prove later on if it's challenged in court that you did it. Here's some of the issues we've been seeing in turnover. So turnover meaning when the file comes our way, okay, it gets turned over to legal. Sometimes there's no collection policy that's been updated. It has to be, so you got to do that. And secondly, a lot of times it's just not signed or it's just not dated. Now, I realize that in the association, you may have had this policy implemented and you're moving forward with it. But when I get to court, or when Deborah gets to court, and we're trying to show the judge these policies, if they're not dated with an effective date and signed, it's like it never happened. So we need to have something in there. We need that signature on all the policies, the date that says, hey, great, policies in place, here judge, here's the document. All right, payment plan again, no longer than 6. You can do 18 equal months, equal payments, 17 payments, 25 in a balloon payment, or another plan at the owner's choice. Now, with your payment plan letter, you might remember that previously your payment plan letter had to have certain requirements in it. So it had to say that they had 30 days to respond, pay in full, or enter into a payment plan. It had to have the contact information as to who to contact to enter the payment plan. and obtain a copy of the ledger. And it had to have a couple of other similar information to what is required into it now. So now the payment plan letter has to say 18 months. You still have to have that breakdown of the balance, principal, late fees, interest, etc. And you have to send it certified mail, return receipt requested, not required, requested. And you have to post it to the unit, and you have to send it one other way. Okay, so 3 ways for that final payment plan letter. Now remember, sometimes your declarations, your governing documents say you have to send every notice certified. And sometimes they just say you have to mail it. In this case, if your declaration says you only have to mail notices to owners, then this is the only one you'll have to send registered for collection, certified. However, if you're in an association where your declaration says every notice is sent certified or registered mail, then any notice you sent is sent certified or registered mail in addition to this one. Plus, you have to comply with the first class mail, email, or text. Don't do text. Then you have to show up, you have to testify that it's really your phone. If we do discovery, suddenly all the texts you sent to your loved ones are now potentially in front of the court. I wouldn't do it. Email, it's okay. I prefer first class mail, that's the easiest to show to the judge, but it just has to be one of those 3. So certified mail, return receipt requested. Why is it not required? Probably because people wouldn't sign for it if it was required, right? So you send it requested. When you send this into legal, you're going to send a copy of the certified letter. You're going to send a copy of the return receipt requested that's with it. You're going to send a copy of the picture of the posting to the unit. Make sure you're posting this letter to the unit. Sometimes we get pictures and it's posted, but it's not the letter that has to be posted. And then you're going to send in whatever other method used. It sounds like fun, doesn't it? Okay. Some of our associations are using process servers to post. Some are just individual board members or management company people are posting, managers. We have one association management company that actually has a security person who's going around posting. So it's up to you. Just be careful because they're very angry about it. We talked about documenting everything. We talked about board voting in executive session to turn over collections, and you have to document it. What you can't do is you can't vote on it via email because the statute is very specific about how to go into executive session, and it doesn't necessarily contemplate that you can do that via email. Now, some of you have action without a meeting provisions, and then we can get into an entire argument, but quite frankly, the easiest way is just call executive session, even if you're doing it once every 2 months, once a quarter. Get all your collections, vote, turn them over. Same with foreclosures. Good so far. Blank stares, nods, okay. We talked about interest, we talked about application of payments. Here's the other part that has to be in that payment plan letter. You have to put in that under HB 1137, that there is now a small claims court option for owners to pursue, or for the association if it wishes to. And you have to put in language about covenant enforcement. Even if there's no fines on the ledger, or even if all of the compliance issues have been resolved, the letter has to state that small claims court is an option, and that if it's covenant enforcement, there's all kinds of other requirements that Deborah's going to get to as well, okay? So, when you turn it over to legal, and legal goes, hey, where's the covenant enforcement language? And you say, well, they didn't have any fines. It's not because I want you to redo your letter, it's because of this. Okay?
Excuse me.
Yes?
Collection language.
Do you have to do collection language? So all you have to say is, and if we drafted your policies, we sent sample letters, or we can, but it basically is going to say, we represent, or we are association such and such, your account is past due, here's the amount, here's the breakdown. Please be advised that failure to cure the balance can result in, and then there's, you can file a lien, you can foreclose, you can turn it over to legal, et cetera, et cetera. You do not have to have in your letters the Fair Debt Collection Practices Act language, because you are not considered debt collectors yet. The association and management companies are not yet considered debt collectors, so you don't have to worry about that FDCPA language. So what happens once a file gets to our office? I can tell some of you were laying awake at night thinking about this, so I'm going to let you know what it is. First of all, once we make sure that you have complied with all of the requirements of the statute, we're going to send a demand letter. Why do we make sure you've complied? Because when we send the demand letter, we're verifying that the balance is accurate and that everything is how it should be. And so we can't send it if we know that there was a part of the law that wasn't complied with. The demand letter to the owner is going to come from the legal firm. It's going to give the owner 30 days to dispute the balance or to pay in full before further legal action is taken. It has the specific language that's required under the FDCPA, which is going to talk about like the dispute process. 2 years ago, in 2021, the FDCPA revamped their demand letter. So it used to actually look like an actual letter that went out that said, hi, we're, Altitude in this case, we represent this association, you're delinquent, it's been turned over, blah, blah, blah. Now it looks more like an invoice or almost a junk mail because of the format of it. So when you open it up, we're no longer debt collectors, are no longer allowed to put a lot of the information on the envelope. So if we say, like let's say our name is Altitude Debt Collection, we can't put Altitude Debt Collection on the envelope anymore. So instead, the owners are going to get an envelope that might say the name of the law firm. It's not going to have otherwise debt identifying information on it. And then inside, when you pull out the letter, it looks like an invoice, and it's very confusing to most people, to most of our owners, because it has the date you made the last payment, the balance of the last payment. If there was no payment, then it goes by the date that you purchased the property. And then it's going to add on legal fees, it's going to subtract out late fees and interest, so on and so forth, and then it comes to the actual total that's owed, which is a combination of all of those things. But it's very difficult to read, and it's very difficult for most people who already throw away a lot of mail that they presume to be junk mail when they get it. But nonetheless, that's what we're required to do right now. So most times they're going to get 30 days to dispute. If they dispute, we have to send what's called a debt validation letter, which is basically saying, here's what you owe, here's why, here's all the documents, and then they get additional time to pay or we can move forward. Sometimes our associations want us to send a few different demand letters, or a follow-up letter, if you will. But for the most part, we're only required to do the one demand letter, and then we move forward to a summons and complaint. So that's the lawsuit. In county court, which is where most of our lawsuits are going to happen in Colorado, we send out the summons and complaint for service before we worry about getting the court date. There's other courts that you actually have to have the court date before you send out the lawsuit, but not here. So with the county court, we get the summons and complaint, we send it out for service with a process server. We have so many days to actually have it served. If we don't get it served in time, you'll see on our reports that it'll be like a redate of a lawsuit or something like that. That's what that means, is the process server was unable to serve the person within the time frame required by the court. Once they're served, we get the return date, which is the date they go back to court to dispute it. If they don't do anything, if the owner files nothing, doesn't show up, we get default judgment. If they file an answer, then that's when we're going to proceed to trial. Now, of course, we may or may not settle before trial, but that's kind of the gist of it. Make sense so far? Okay, so what we're going to do is, let's say we go from answer across to pretrial conference on the left side. Once the answer is filed, assuming that there is valid defenses or counterclaims, we go to pretrial. The courts, most of our courts, particularly in the areas on the eastern frontier, are requiring mandatory mediation. Some of our mountain courts don't require that. Then if we resolve at mediation, great, they enter into a payment plan, or they pay, or they do whatever the gist of it is that we resolve at mediation. If not, we go to trial. If we lose in trial, no one's happy. If we win at trial, only one person's unhappy. And then we get judgment. Likewise, if on the right, we go from answer to default judgment, so they haven't disputed anything, the court enters judgment by default, saying, well, there was no dispute, so by default, the association wins. And then that's when we're going to move into collection actions, such as garnishments, receiverships, etc. Okay? Part of collecting from the assets is going to be sending out what are called asset questions, which are interrogatories. And then the court will order the owner to answer them, so on and so forth. Yes?
So do they actually have to be personally served? And if they're not found, does it mean none of this process happens?
So, both. One, we try to get personal service on the lawsuit. However, the service law says that we can also serve by refusal. So if the person is there and they say, I'm not taking your paperwork, the process server can still serve it, generally by dropping it because they refuse to take it, and then sending out an affidavit that says, hey, I tried, and here's all the identifying information, so I know it was the right person I served. We can also serve an adult who happens to reside in the same household. Now, let's say that none of that is happening, and we don't know where the person is, and no one has a forwarding address, and we show up and the person says, well, no, I'm a renter and I haven't seen them in months, then we can't do this at all. Now, there's other options. If we know where they work, we can serve them at work. That tends to make people very happy. But for the most part, though, we have to get some type of what is called personal service to move forward with a lawsuit.
Thank you.
Okay, so 2 options we have for garnishing once we get judgment. We cannot, of course, garnish before judgment because that wouldn't be cool. So writ of continuing garnishment, that's your wage garnishment. So the wage garnishment is nice because we can get up to 25% of their net disposable income, so the income after taxes, and we can serve the employer first, and then most of our owners find out from the employer before they're ever actually notified there's the wage garn, because the employer gets served first. However, if they're unemployed or there's 5 garnishments ahead of us, which happens, then we're going to be taken kind of down the line and they'll let us know eventually. So it works when it works, but it doesn't always work. And then the other is the bank garnishment. So the bank garnishment, we file paperwork with the court saying, hey, can we garnish the account? The court says, sure. And then we go and we serve the bank and the bank holds the money. And then we have to serve the owner. If we can't serve the owner, then we can't get the court to order the bank to release the funds. Okay? The other thing that happens with this one is sometimes there's no money in the bank. Sometimes the credit report that we can pull after judgment's entered says they bank at Wells Fargo. Wells Fargo says we haven't seen them in years. So there's issues here. This one is great if there is money in the account because it's going to pop it and if you hit it correctly, you will get a large sum. Let's say it was just after payday. The downside is most people pay all their bills, and so if you hit it, 3 days after payday, it might say 0. And there's other issues, like you hit a bank account and the bank's gonna seize money from any account the owner has their name on. Well, if I have my name on the account with my mom and maybe it's her money, they're gonna seize it all and hold it, and then I have to go in and prove that it's mom's money and not mine as the owner. So sometimes there's some tough conversations.
So when you say bank accounts, does that mean IRA accounts as well? Just?
This means, yeah, your run-of-the-mill financial accounts, checking, savings, etc. So if you remember during COVID, there were some laws that were kind of passed, emergency laws to help people because people weren't working and everyone was trying to live off of whatever money they had. And those have expired now. At the time, it was the first $4,000 was exempt. So that has changed, and now it's $2,500 is exempt, but instead of an automatic exemption, meaning we weren't able to touch it as a creditor. Now it's $2,500, and the owner actually has to raise that issue to the court. During COVID, it was automatic, and the bank would come back and say, no, it's under $4,000, and that was the end of that. Okay, so, you still with me? Okay. So what do we do when we can't serve an owner, or we have an owner who has property that they're renting to someone, or the house is vacant? This is one of our options, is receivership. So with a receivership, the court orders the person who is the receiver, and there's companies that are full-time receivers. The court signs an order saying you can be a receiver to this property. That allows the receiver to go out and either install renters in the property and then start collecting the rent for the association, or intercept rent from whoever is already in the property renting. This does not mean that the association is now responsible for the mortgage. It doesn't mean anything like that. All it means is that it's another way for the association to recoup funds owed from them under court order. Now, the good thing about receivership is that if the property, we have an owner who just isn't in state, or we have a lot of owners that come through our office who live in different countries. We can't serve them over there because service is a US thing. So this is an option, is to do a receivership. When a receiver does a receivership for the court, what they're going to do is collect rent. They're going to pay themselves first and then pay off the association. The downside of receivership is it can be expensive if the property is not in very good shape, because the receiver would have to bring the property up to rentable condition. So if you come to me and you say, we have a vacant property and we want to do a receivership, and then the receiver looks at it and says, well, we have to do mold remediation, and that's going to cost $20,000, you're probably not going to want to do a receivership. On the other hand, if you come to me and say, let's do a receivership, and it turns out that there's just a bunch of weeds and the lawn needs mowed, that might be a good option for receivership. That's an easy fix to bring it up to rentable condition. In this process, we can do receivership at any time. We can even do it while another foreclosure, like let's say the bank is foreclosing, we can do it in the interim to collect rent. The receiver is required to file a report with the court quarterly that says, here's what I did, here's how much money came in, here's how I dispersed it. I will tell you, if the tenant is already in the property, we will hear from the owner very shortly as soon as he stops getting rent from the tenant. Because the receiver will go out and say, here's the court order, you're paying me, and pretty soon I get a call from the receiver that says, I heard from the owner, they want to know what they can do to get the receivership released. Which is great, because sometimes they don't respond otherwise. The other thing we can do with this, as I was talking about earlier, is if there is a pending foreclosure now. If their bank's foreclosing next month, you're not going to want to do a receivership, that's not enough time. But if the bank just filed its foreclosure and we have 12 months before the property is set to sell at foreclosure sale, then it might be a good opportunity for the receiver to come in. And they're going to collect rent based on kind of the market value of the area.
Are there attorney fees or covered provisions for getting the judgment in favor of the association and also for post-foreclosure?
Right, so when we go into court and we request judgment against the owner, we're going to include all of the legal fees and costs that are incurred to date. And likewise, when the receiver goes in and we file the receivership, we're going to submit to the receiver the full balance that we're asking for, which is going to be whatever is owed to the association plus legal fees and costs, including whatever the association has already paid, because the association under Kiowa is allowed to get reimbursed for those costs and fees. Right. Receivership is going to generally run, it's going to be pricier than just your average run-of-the-mill lawsuits and garnishments, with the exception that if we have to hit bank after bank because we can't find an account or they're all closed. It's going to be less expensive, usually, than a foreclosure. But they work hand in hand together, so they're good options to consider. But again, you want to look at it case by case. If you look at it and you say, well, we're only owed $1,000, you're not going to want to employ a receiver for $1,000. Likewise, if there's $20,000 in mold remediation, no. But if you're owed $5,000, then it probably is a good option to get that receiver because he's going to collect that money too. Now, can anything go south at any time with any of this process? Sure. We might be suing an owner and then they pass away. We've had that happen. And then it's in a holding pattern hoping there's an estate, and then your other option might be foreclosure. We've had people file bankruptcy or people sell the home. So anything can cause the association to be out its fees and costs. The problem is, or the issue, I guess you should say, is what we want to do is what happens in probably 95% of cases, 98, is we want to recoup all of that money regardless of the process we're doing. That's the goal. Okay, so foreclosures. Why do you foreclose? You can't foreclose just because you don't like them. I mean, you can, but you shouldn't. So one, if it's a chronically delinquent account, frequent flyer, they're in our office, they get a zero balance and they go back to not paying again, that would be a good reason to foreclose. If it's a judgment-proof account, so if they have, let's say their only income is Social Security, we cannot garnish Social Security, it's protected. Your option then might be to foreclose. It doesn't sound great. People don't like to foreclose when they know someone's only income is coming from something like Social Security. But my job is just to tell you what the options are. If they have a large account balance, so if they have an account balance that you're like, listen, they already owe $15,000 and we don't really want to sue and then garnish their wages at 25% a crack, that's going to take forever. If they are a company, bank, LLC, etc., so if the property's been put into an estate, if it's been purchased at a foreclosure by an LLC, the bank owns it. If we can't find the owner, or we can't find them and we don't know the property's vacant, or we can't find them and the property has significant issues, mold remediation again, something like that, then those are all good reasons to foreclose. When we don't want to foreclose is one, if there's no equity in the property or little equity in the property. Because then you're going to end up owning a house that's not worth much and you still have all this money that's owed to you. The second thing is we can no longer, and we did not recommend this previously, by the way, but we can no longer foreclose just on covenant fines. And I don't, do you guys remember when, was it Green Valley Ranch has been in the news lately, right? For the foreclosing, okay. So this came out of HB 221137, the covenant violation fines. Foreclosures, uncontested, that means the owner doesn't respond, doesn't care, says go ahead, take it. Then you're looking at about 9 months. If the owner fights it, it can take a year or longer. Why? Because you'll go to trial, you'll go to hearings, you'll have the sheriff's sale, maybe there's a bankruptcy filing, all kinds of things can interfere with it. So what happens when we foreclose? Sometimes all we need is a letter to go out the door that says the association's hired us to foreclose, and suddenly there's a lot of money in the office coming in. We have associations because you have to sign that resolution that says you're going to foreclose. You can't just send a letter saying, we're going to foreclose unless you sign the resolution, because otherwise you'd be in violation of law, and we can't threaten it unless we know you're going to do it. But I can tell you, if you sign the resolution and send that letter, we get a lot of very quick responses. It's kind of like the receivership with the tenant rent. If the owner does not pay, then we go to the sheriff's sale, and a lot of times we will have a third party, oftentimes an investor, who will come in and purchase the property at the sale. So they basically pay off the association, and then they pay off the mortgage, they own the property, they do whatever they want with it. Sometimes in the middle of our foreclosure, the association's foreclosure, the first mortgage starts their own foreclosure. Well, that can be an issue because we want to either A, beat them to the punch, or B, withdraw because we're going to lose to a first mortgage. Because remember, we only have that 6 month super lien, 6 months worth of assessments that trumps the first mortgage, but otherwise the rest of our lien is junior. Now, if it's a mortgage that's started by like a home equity loan, well, then we're still fine. They'll probably pay us off. And then sometimes the association becomes the owner. Now, sometimes the association wants to become an owner. They will take the property, they'll turn around, they'll sell it, they'll pay everything off, everything's good. Sometimes they keep the property, they refinance, they rent it out. Sometimes they say, please don't ever let us be the owner, we don't want to be in the business of real estate. The association does become the owner, they can sell it. You can rent it out until the mortgage does come in and foreclose, because again, even though you foreclosed, it doesn't mean you're responsible for the mortgage, because the mortgage is a contract between the owner and their company. Or you can refinance. And again, that's for people that just want to be in the business. Go ahead.
What happens if taxes, property taxes come due within that 9 month or 1 year period?
So the property taxes, if they were to foreclose, would trump everything, even the first mortgage, right? But as far as your liability for doing it, you don't, as an association, you're not liable to pay the property taxes while you're doing your foreclosure. Now, if you were to own the home and refinance it or pay off the mortgage, and now it's in the association's name, then you're responsible for the property taxes. So it would depend. If you plan as an association on purchasing the home at the foreclosure sale, then you might want to talk to your attorney about paying those taxes off before they get to the point that they're foreclosing, although that's generally a little longer process. Or two, you just say, okay, whatever, we're still gonna foreclose, get our money, and whoever buys it can deal with it. It's very general though, so call and ask. All right, who's ready for bankruptcy? This is no one in the office's favorite topic except mine. Okay, so there's two kinds of bankruptcies. There's actually much more than that. The two we primarily deal with in our office are going to be Chapter 7s and Chapter 13s. You may have also heard of Chapter 11s, Chapter 12s, and Chapter 5s. We don't see a lot of those. The ones that the owners file tend to be 7s and 13s. 7, that's known as a liquidation. That does not mean that they come in and sell everything you own. What it does mean is that if there are secured debts the owner wishes to keep, like the house or the car, they continue paying them. If there are assets that cannot be protected, so I have a vacation home in France, that's probably going to be sold by the trustee to pay off all my creditors. And so you're looking at 4 to 9 months, 3 to 5 months if it goes smoothly. And then once the owner has completed their bankruptcy, then everything is discharged. Not actually everything, this is why. The personal liability is discharged. So I can't come and garnish you if you filed bankruptcy for the debt that you owed me before you filed. But I could still foreclose on your house because that's the lien. And I can still foreclose on the lien. People get so mad about that because they think, well, I filed bankruptcy and now you can't take my house. It's like, well, no, I can't collect from you personally, but I can still take your house. It's not a fun discussion. It can kind of sometimes be a fun discussion. Anyway, that's in Chapter 7. How does it affect you guys? Anytime there's a bankruptcy filed, there's something called an automatic stay that goes into place. What that is a hold on any collection activities or attempts to collect a debt or actions that are in furtherance of collecting a debt. Now, what the hell does that mean? This is what it means. If your association, for example, sends letters, because remember now you're required to send those letters under state law, that would be a violation of the stay. That's why we're telling you, you need to have language on there that says, we're just doing this to comply, it's only for informational purposes, we're not collecting a debt. If your association has a pool, and when someone's delinquent, you suspend them from using that pool, and they file bankruptcy, you have to let them use the pool. Why? Because that is an action taken in furtherance of collecting a debt. Okay, so don't forget those two. The pool's a big one, especially this time of year. All right, again, personal obligation. Personal obligation just means we can't sue them in county court for the balance they owe to the association that was owed pre-bankruptcy filing. That's called pre-petition. But we can still go after the lien. I thought you were raising your hand. I was like, now's not a good time. Okay. Here's a very valuable piece of information. In a bankruptcy, the owner can surrender the property. That doesn't mean they fly a white flag and say, please come take it. What it does mean is that they say, hey, we don't want this property anymore, and we don't want to be obligated to pay the mortgage. So they surrender it. Their other option is to keep it and pay it. If they surrender the property, or if they just say, we filed bankruptcy and we don't care anymore, this part of the bankruptcy code, 523A16, says they still have to pay the assessments that come due after the bankruptcy was filed, post-petition, post-bankruptcy petition, until and for as long as they own the unit. So if you have an owner who says, I filed bankruptcy, I surrendered the house, I don't owe you jack, you say, actually you do, you're still responsible until the property changes names. Okay, Chapter 13. It's 3 to 5 years. It's a long haul. Only like 70% of people ever finish it because a lot of stuff happens over 3 to 5 years. What do they do in a Chapter 13? A Chapter 13 is basically a repayment plan. It's still a bankruptcy. They're still discharging their unsecured debt, so the debt that doesn't have a lien on it that's not in exchange for property collateral. But they can take the past due amounts owed to the association or to their mortgage or to their vehicle, and they can put it all into their Chapter 13 plan and pay it off over time at 0% interest. It also has an automatic stay. Okay. It also has an automatic stay. The debtor can still surrender the property in the bankruptcy. They would still be responsible for those post-petition assessments, fines, late fees, et cetera, that come due. But if they surrender the property in the bankruptcy, then they don't have to continue to pay the association that pre-bankruptcy balance through the plan. However, the lien on the property remains, but there's lien stripping. That doesn't mean liens go into a club. Here's what it means. Lien stripping is you can file what is called an adversary in a bankruptcy. That's a fancy bankruptcy word for lawsuit. If the property's underwater, then the person can go in, their attorney can go in, and they can say, we're filing an action against all of these people that hold liens to void the lien and get rid of it. Because the property's underwater, there's no equity for it to attach to, voila. Here's what actually happens. They have to finish the bankruptcy. 3 to 5 years is a long haul. If they actually receive the property, the bankruptcy discharge, the association's lien, the pre-petition lien, because remember, an association's lien under Kiowa, they have a lien every time they miss an assessment, right? Your lien kind of keeps going. But as far as that pre-petition balance, it would be gone. You couldn't collect it because it's stripped. Okay. I feel like I should sing with that. All right. For the bankruptcy, particularly in the Chapter 13 plan, you're going to get notice of the bankruptcy, and you're going to get notice. On that notice, it's going to tell you what the deadline to file a claim is. It's going to be roughly 72 days after the date of filing. And you're going to get notice of a Chapter 13 plan, and the plan is going to have all kinds of information in it. And you're going to need to see if your association is listed in the plan, how much they're planning on repaying you over 3 to 5 years, and if it has your monthly assessments in it. Here's 2 things that can happen. 1, if you do not file a claim, this changed in 2014, so you're now required to file a claim. If you do not file a claim, which is a piece of paper saying this is what they owe, along with your declaration and ledger and all that stuff, they don't have to pay you. Because you have a claim against the home, secured claim, your lien is still there. They just don't have to pay you for 3 to 5 years, and you can't continue to get interest, all right? The other thing is that, let's say you do file a claim before that deadline, but you don't look to see if you're in the Chapter 13 plan, and the plan gets approved by the court, then you're done. Whatever the plan was confirmed at, whatever it is approved at, it is approved at. So if the owner owes you $5,000, and the plan says they only owe you $2,500, and you don't object to that plan and get it fixed, you're getting $2,500, and that's it. Okay, so what do? 1, call somebody, get it to your attorney, doesn't matter, highlight, put it in your calendars, get those dates on your calendar so that you don't miss the deadline. 2, turn it over to legal. Our office will monitor them, but we will also do like the claim and everything for you. So just pay attention. We miss these a lot. Because you get the paperwork and life happens, and then suddenly it's 4 months down the road and you say, well, they filed bankruptcy. Well, now it's too late for me to do anything, especially if you got notice to begin with. The court's like, well, no. All right, so let's say you filed a proof of claim, you're in the plan, everything's golden, and the owner stops making assessments a year from now, assessment payments. We can move to dismiss the owner's bankruptcy on the basis that they're not complying with their plan. Or we can ask the court to convert it back to a Chapter 7 so that it's over with and we can proceed with foreclosure. Or we can ask the court for relief from the automatic stay, that hold, so that you can foreclose. So you have some options there, but only if we're in the plan to begin with and file a proof of claim. If the owner surrenders the property in the Chapter 13 plan, you still get that claim that you filed, because of course you filed before the claim deadline. But we become an unsecured creditor, so we get less money on the dollar. We can still foreclose, but we just won't get paid as much through bankruptcy. Okay, questions, comments, concerns, emotional outbursts? Yes.
Does, altitude community education, the attorneys there, do they only represent HOA associations or do you represent owners?
So we only represent community associations, so HOAs, condos, etc. We do have what's called a business law group, which primarily represents businesses that are non-HOA type of actions. But we don't represent owners against associations. Yes, sir.
Has the new laws gone on to give us an idea of what the track record is for the HOA coming out on top because of what those rules?
So in my opinion, no. Deb might have a different one. And this is why. On the collection side in particular, because of the 18-month payment plan, we haven't had files being turned over for owners that have entered into that payment plan, but it hasn't been long enough that there's been enough time for them to default either. So we don't know how the outcome of that's going to go. Now, what I am hearing from our management companies is that, one, people are very angry about the posting on the door, even though that's not the association of management companies' fault. But two, it is working almost like a scarlet letter where people are just sending it in because they don't want the darn notice on the door. With some of our other things that are coming out, like flag and signs, for example, that happened 2 years ago. The association can no longer regulate the content of flag and signs. And that one has been out long enough that we have a lot of people in associations who, let me explain it this way. Everything's fine and good as long as all the flags and signs match what I think they should. But if I'm an owner who doesn't like the other owner flag and signs, then I'm like, why aren't you guys doing anything about this? So we're seeing kind of that, I don't know what you would call it, backlash against it. Anything else? Yes.
If you've levied an assessment and somebody's taken the payment plan, the 18-month payment plan, and it's been posted on the door and all of that, but are you, the management company then would still send a monthly invoice to them every month then saying,
Yeah.
okay.
Yep, so even though the owner's entered a payment plan, you still have to go through the whole process. Now, the owner's gonna call you and say, why are you wasting money? I'm in a payment plan. It's because you have to. Likewise, if you post it on the door and then you also mail that letter as you're required to, the owner's gonna say, why are you mailing this letter? You posted it on my door, or vice versa, why are you posting on my door? I got your letter. You still have to do it, and you should do it at the same time, because otherwise, you have to let that 30 days run, right, from the time you send it. Well, if you post it on Friday, and you don't mail the letter until Monday, and it doesn't get there till Thursday, the 30 days has to run from the date of that letter and not the date of the posting. So try to do them at the same time. Yes, ma'am.
My question is, if a homeowner files bankruptcy and the company, or like the HOA is not notified of their bankruptcy, how does that work then? Because you're still sending them letters and that to collect.
So first of all, with the bankruptcy, if the association is not listed, and let's say it misses a deadline, but they never notified the association, there's a thing called a creditor matrix, which is a mailing list that they file with the bankruptcy court. If the association and its management company isn't on there, or its management company, then the association would not have had notice. And you can't, although you can violate the state unintentionally, the court is going to look at a number of factors, including whether or not you knew or could have known there was a bankruptcy. So if you're sending letters because the owner never put you on the bankruptcy and you never received notice, it's gonna be okay. However, if the owner has you on there or put your collection agency you were using and you're still sending letters, that's when you're gonna have a problem. And the violations of stay are about $1,000 a pop for each violation. So if you send 4 letters, that's $4,000. And then the attorneys will claim like emotional distress and things like that. So if you're not on there at all, I would still, as soon as you find out, stop sending them, get it over to the attorney. But if you know, get that paperwork in before the deadlines and stop sending the notices and put that bankruptcy language on the bottom of any required notices that you have to send pursuant to state law. All right, anything else? Yes, sir.
This payment plan that you can negotiate, if I understood what you said correctly, the owner really has the whip hand. they can insist that they only pay, they know what they're doing, $25 a month.
Yep.
So if you have a large amount of money, say a special dues assessment of $10,000, at $25 a month, and you're charging 8% interest, you'll never even collect the interest, let alone the $10,000. So what is the option of the association in negotiations with the owner? Just say you don't agree with it, and you proceed to the attorney, or what can you do?
Nope, so you have to allow them to pay $25 a month plus ongoing assessments. Like they're required to do the ongoing assessments. But in your scenario, they owe $20,000 and you're charging $25 a month, they're not gonna get it paid off. You have to let them do the 18-month payment plan, and in month 18, when they still have an $18,000 balance, that's when they default, and you can send them over to legal.
Even though they've been paying their $25 a month, that's regarded as a default, and then you can proceed to go to the attorney
And the reason it's a default, so remember earlier I said you had to have 3 missed payments to default. But in month 17, when there's that balloon payment coming up in month 18, there's no more than 3 payments left to miss. At that point, if it goes to month 18 and they don't come up with the remaining balloon payment, they're done, it goes to legal. Okay, one more and then I'm gonna turn it over to Deb.
When you send the invoice every month, you don't have to post that every month, do you? It's just the first time.
Right, so the regular delinquency notices are every month in mail. The only letter that has to be posted and sent certified mail return receipt requested and one other way is that payment plan letter. So the letter, whatever part of your collection policy where you send out the payment plan information, sometimes it's the first one, some associations don't send it till number 3. That's the one that has to be posted and sent certified. Okay, I'm gonna turn over to Deb and then I think we'll take questions at the end too.
Okay, we'll see if I can get through mine as well as she did hers. All right, as you've heard, I've been doing this a really long time. However, I just got over a cold, so bear with me. I'll try not to cough and break your eardrums into the mic. I put this slide in just so that it's in your handout. If you guys don't know about Altitude, we put tons and tons of things on our website, including we do monthly webinars, and we now put them on our website. So like you missed the webinar and you go, oh, I really wanted to listen in on that topic, you can now find those if you go to our website. So there's a lot of information there. It's always useful and helpful to start your research there because it's obviously cheaper than calling us. Okay, so when you think about covenant enforcement, I start with this slide and people look at me like I'm an idiot, but it's kind of important because if you don't know what a covenant is, you're going to use the wrong language. And a lot of times people call us as attorneys and ask us questions and they'll say, it's in my bylaws, or it's in, it's a covenant. And we go looking through your covenants to find something, or we go looking in your bylaws to find something. These are defined things. Your bylaws tell you how much quorum you need. They tell you about proxies. They tell you about board members. They don't tell you about your covenants. Your covenants are recorded with the clerk and recorder, and they're considered something that runs with the land. Why is that important? Because they never go away without that vote of the homeowners, that super vote that's either 2/3, sometimes we'll see 51%, but they are attached. And once they attach, they are the strongest thing. When we talk about rules, okay, not nearly as strong. Probably a lot easier to understand because they're drafted by board members rather than attorneys. And so your homeowners want to look to the rules first because it's clear, they get what they are, but not hear the weight. Why? Because they're not created by the homeowners as a group. They're not recorded with the clerk and recorder and there until voted by homeowners off. The difference to a court between a rule and a covenant, night and day, guys, okay? The court doesn't care if the covenants are reasonable. I know that doesn't make any sense, but you had the choice to not buy that house. And you chose to buy that house, and when you chose to buy that house, you promised to comply with those covenants. If you didn't want to comply with them, you shouldn't have bought the house. And because they're recorded with the clerk and recorder, you are deemed to know they exist. Every homeowner who's ever come to you and said, I didn't know it was there, I didn't get these, nobody gave me a copy, you can go, I don't care. Because it doesn't matter. The court deems they know it, because it's recorded with the clerk and recorder, and it is their obligation under their due diligence when they buy a house to read them. They didn't bother, too bad, so sad, dude, not my problem, okay? A rule, the most important thing to remember when you're drafting rules as a board is the court can choose to ignore your rules, can decide they're not valuable, they're not reasonable, they're not in furtherance of your covenants, and throw them out, okay? When you draft a rule, you cannot contradict the covenants. You can't try and amend the covenants and just call it a rule, okay? You have to be furthering the purpose of the covenants and just trying to clarify. Perfect example, many, many documents, and I would say more than 90%, give or require pre-approval to do an alteration to your property, right? And most of the time when you read that covenant, it gives you pretty much carte blanche. Homeowner may not alter without pre-approval of the board. But it doesn't tell you in the covenants what the board's gonna require for pre-approval, right? Perfect thing to do is to have design guidelines. Tells your homeowner what you're going to require. I'm gonna allow you to have sheds, sure. Can't be taller than 8 feet, they have to match the house, they have to have the same siding, they have to be the same color, whatever. Tell them in advance. This does two things. One, it's gonna make you consistent. Okay, it's not gonna be, oh, I really like this lady, oh, I can't stand her, so she can't have a shed, but you can, right? No, I have set rules. Here's the rules, here's who can have a shed, here's where you can put it. Everybody gets treated the same because you put it in writing. It also avoids the one way that the courts will throw out an ARC, Architectural Review Committee's decision, arbitrary and capricious conduct. If you create rules that say what you're going to do, what you're going to allow, when you're going to allow it, you give yourself the support so that when you walk in the courtroom and the court goes, well, why did you deny her that request? Well, because she wanted the shed in the front yard and our sheds are only allowed in the backyard. See, here's the rule. I'm not arbitrary, it's in the rules. Everybody has to follow it, right? You've just given yourself support. So rules are very useful, very helpful, but they have to be in furtherance of your covenants. Okay, when we talk about the covenants, there is a hierarchy. The federal law trumps all of it. Now, how often does the feds get involved in an HOA? Tons. How many of you guys got satellite dishes? Okay, federal law, the OTARD rule, right? Over-the-air recording device tells you whether or not you like satellites or not. Everybody gets them because it's part of the federal rule. So feds get involved a lot more than we probably think about. State law, obviously, for most of you is Kiowa. Is everybody here part of Kiowa? Is anybody a non?
We're a pre-Kiowa.
So you're pre-Kiowa. Do you have anybody who's exempt from Kiowa? No? Okay. So for most of you, then Kiowa is going to be the controlling main law that you're going to look to, although you're also going to look to the Nonprofit Act. That's also going to have some light into some of the things you do. The next thing is going to be ordinances. And I say sometimes, because think about it. There's a local ordinance that went into effect, I want to say 3 years ago, that said owners can have chickens. How many of your board members or how many of your homeowners were like, oh my God, no chickens? Okay, and everybody was afraid that that new law was going to mean chickens were coming in everywhere, right? And the law was written so that only those communities that didn't have covenants could have chickens. It didn't trump. It wasn't written to trump. Okay, it was meant for areas not covered by covenants. So after all of those, then you get your declaration. Okay, your declaration of covenants, your strongest document recorded with the clerk and recorder, and your plat map. If you don't have your plat map for your community, go get one. Okay, make sure you have the plat map. Why? There's notes in the plat that tell you things. Tells you you can't subdivide. Who has a maintenance responsibility for a particular area? Is there another subdivision agreement that's referenced in the document? You didn't even know it existed, but it's referenced in the plat map. it is equal to and at the same level as your covenants. So if you've never found it, go to the clerk and recorder and go get it. It's an important document.
Can we clarify a word? Is a declaration the same thing as a covenant? Because we're a pre-Kyle law, we have declarations, we don't have covenants.
You do have covenants. Covenants are covenant is the legal defined term of that document that binds and attaches to land. The declaration, it's generally called a declaration of covenants, conditions, and restrictions. So the declaration of covenants, that's one thing, okay? Sometimes they're called protective covenants. Most of the time, they're the older the document, they're more likely to be called protective covenants. The newer documents all call them declaration of covenants, conditions, and restrictions. So then after the declaration, I have bylaws, and then articles, and then rules. Sometimes you'll see the bylaws and the articles flip because they're contracts. And the drafter can say this one's more important than that one, right? That's a choice. So different documents can be different on that one. At the bottom, you see rules, guidelines, and policies. And why do I put them all in the same line? Those are all crafted and created only by a board. Board vote only.
Quick question on rules, guidelines, and policies. Are they required to be filed with the county to update your documents? If they're not, are they enforceable?
So we do not recommend that you record your covenants, we do not recommend you record your rules, your guidelines, and your policies. Why? Because they can be amended by a board vote. And as they're amended, the more you have recorded versus what you have that's current, there'll be more confusion. It does not make them stronger to record them, okay? They still are only adopted by a board and still hold that same weight. So recording them does not make them stronger, and so no, you do not record them.
So rules, guidelines, and policies cannot be in deference to your declared covenants. Is that correct?
In deference.
I'm sorry, they do not supersede your declaration of covenants.
No, rules, guidelines, and policies only support your covenants.
Okay.
Now, understand, let me give you an example of a case to just make it muddy. Amanda already brought up the sign statute that went into place, right? So many of you might have covenants that say no signs, and then the state law came down and said, oh yes, everybody can have signs and they can say anything they want. And we suggested to all of you to adopt policies to make it clear to homeowners what you would allow. And so that policy on signs is going to contradict your covenants. It's only valid because the law told you this is what you need to do.
If we have in the covenants, no sheds, it spells it out.
Mhm.
We cannot have the rules, guidelines allow sheds.
Correct. Did everybody hear that? Okay. Wait, did I hear a no? No, okay.
I'm just wondering to what degree rules and guidelines can be enforced.
To the same degree as the covenants, so long as they further the interests of the community. Okay, purpose of the association. Again, if your rules further the purpose of the association, they're as strong and as enforceable as your covenants. Because this is the biggest way that a court will attack your rules. So the main thing is, as a community, your biggest goal is to preserve, enhance, protect. You're protecting property values, right? That's your biggest goal. And if your rules are such to seek to help do that, along with the covenants, not contradicting your covenants, they're going to be as strong as the covenants when you go to court. Now, promoting harmonious community living has been kind of dumped upon us as HOAs. It is not the basis and not what covenants were ever designed to do, but because it has just been dumped on us, the HOA, to kind of deal with, because our homeowners are screaming, You know, their radio is up all night, you gotta make them turn it off, and they want us to fix that. Harmonious community living has been added to a lot of our rules. We're gonna get to the point where HB 1137 kind of gutted that, and we're not gonna have any ability to do anything about it, but that's been added as a purpose. The common scheme, that sounds like a weird term, but that's actually in case law. Before Kiowa, sometimes developers didn't always get everything recorded properly. And so there was a lot of case law out there that said, if it's very clear from the deeds and the documents that there is a common scheme in the community, the courts would hold everybody responsible to maintain that common scheme. Kiowa has changed that significantly to dot your I, cross your T when you do an amendment, or it's wrong and we're throwing it out. Right now, there is a lot of fighting in the courts over which of those is right. Dot your I's, cross your T's, common scheme. We don't have the answer yet. So as a litigator, I'll tell you, I still put both these on my slide. They're still going through the courts. We're still seeing it, but there's a lot of pushback if the declarant goofs it up, because Kiowa is kind of leading the race right now. So be careful what you ask for when you send your demand letters. It's a funny slide, but it's only funny because it didn't happen to you. If you were the board members that have sent, 5 letters telling them to paint their fence, you're probably not that amused at, look, Bob, I painted my fence. You have to be really careful what you're asking for in your letters, because if you're not clear, if you're not specific, this is what you'll get, and we won't be able to fight it in court. So you have to be very clear, and HB 1137 actually came out and made it very clear as well. Remember, House Bill 1137 said, you have to send a letter that says, this is what you're in violation of, and this is what you must do to fix it. You have to be clear about both those. So, be careful what your letters are demanding. You also have to be really clear and think that not everybody decorates the way you do, okay? Just because you think a lot of flowers are great, if you care about how many containers or what those containers are, you need to think about it when you're drafting your rules. When we start looking at covenant enforcement, we're going to start down this path. How do we enforce the covenants? The first thing you need to think about is, how did you come to know about the complaint, the violation? Now, to you, it makes no difference how you found out about it. To a judge, it does. Why? Because if it's an owner-to-owner complaint, because if Amanda went to HOA and said, Deb's landscaping looks awful. I mean, she really needs to maintain. It's just terrible looking, right? And the board knows that Amanda can't stand me. Well, then they're probably not going to listen to what she said, right? Now, if she brought a picture of the toilets lining my driveway, they might agree with her, right? But you have to think about why you got the complaint. Is there a bias? Bias becomes very important when you get to court. So if you have those 2 squabbling neighbors and they're constantly yelling at one another and they constantly try to make the HOA in the middle of their argument so that you fix and deal with their problem, you're gonna want photos, okay? You're probably gonna want more than just one of those 2's complaint in front of you. However, if it's a manager who doesn't live in the community and drives up and down the streets and doesn't know anybody, that's pretty objective, right? They don't know anybody, they don't know who lives in the community, they really don't care, they don't have an axe to grind. There's gonna be a lot more objectivity in that manager complaint, okay? And so it's gonna have a higher weight. What about a board committee member? They kind of are in the same boat as the owner because they are an owner in the community. And if they know that person, their position may or may not have some bias to it. And so, look, all of us have friends, all of us have buddies, all of us have people who drive us to go drink, okay? We all have those, right? Okay? And if one of those persons who drives us just nuts happens to be our neighbor, well, you as a board member, you don't have to get mad about it, but you just need to know it, because when you get into court, you're gonna have a lack of credibility. So if you have those 2 neighbors who can't stand one another and they bring you a complaint, and the complaint is a boat in the driveway, the boat's either there or not. There's a photo of the boat in the driveway or not, right? It's pretty simple, it's cut and dry, even though we know they don't like one another. But if it's over noise and how loud the other is, maybe we need a second opinion, okay? So just be aware of biases. So when we start talking about enforcement options, I know it sounds funny that the first option is no action. But we'll get to that because it becomes important. But there are a lot of different options about how you're going to enforce. A while ago, before the law changed, this slide was used for a different description. But now that the law's changed,
Yes.
you can't do anything about this.
It's the signs of the
The sign law says you cannot control content. You can do nothing about that. So when the neighbor comes to you and says, make him take that down, you get to say, I can't. Sorry, go talk to the legislature, but they told me I cannot control the content of signs. Okay? So even though you may have had something in your covenants that said, no signs, you're gonna respond back to the neighbor who's upset about the sign, I can't do anything. Okay? So sometimes there is a duty to enforce, right? If you have a valid covenant violation. And when I say duty to enforce, I'm talking about a board member's fiduciary duty. And that fiduciary duty is to do your best to enforce your covenants. Now there are times that you are gonna say, from a business standpoint, I can't afford to do it. I can't prove it. The law trumps my covenants, so I can't do it. There are different answers that you as board members are going to come up with. But when you make the choice not to enforce, you need to document it, okay? As a board, you have some protections so that you do not get sued for breach of your fiduciary covenants. Fiduciary obligations, sorry. So to make sure that you're not sued for breach of fiduciary duty, you have to meet kind of one of these reasons why you're not taking action. Why as a board, as a businessman, remember, you're a corporation, you're a nonprofit corporation, so you have to put on your business hat and say, what's our duty, what are we gonna do, why are we gonna do it? And if you come up with this after you analyze the facts, you analyze what you can do, and you come up with, I don't think we can afford to enforce this right now, document that, okay? Why does it become important? Because in Colorado, there is a rule called the business judgment rule. The business judgment rule says courts will give deference to the decisions of the board if made in good faith, right, after due deliberation, right? So if in fact you act like a business and you make sure that you look at all the facts, your decision is what's in the best interest of the community, your decision is in good faith after you're fully informed, then even if it's the wrong decision, the court will give you deference. And what do I mean by that? So the easiest way to explain it is a case out of California. It was a termite case, it was a condo building. HOA did some investigation, found termites. They had reserves, not tons and tons, but they did have reserves. They called in experts. Experts presented a plan. We said, we think this plan will work. One of the plans was within their reserves. They followed that expert's advice. They implemented the plan. They spent their reserve money, and they didn't kill any of the termites, and the building went down, right? So, of course, what happened? Guys who lost their homes sued the board and said, you guys made a mistake. You chose wrong. And the court came back and said, no. They did what they thought was best in the best interest of the community. They went to an expert, and the expert gave them this advice. They followed that advice, and yeah, you're right, it was wrong, but they didn't do anything willful or negligent, so they're not at fault, okay? So when you, the board, make a decision not to take an action, or to take an action, you need to make sure that your notes, and this is why you have minutes, guys, your minutes are what protect you from those lawsuits, and your minutes reflect that this is the case. We called in an expert. We got fully informed. We made sure we knew all the facts, and we made a decision. Even if the decision's wrong down the road, you won't be liable, okay? So that becomes very important. Sometimes you don't know who left you the present, okay? Even the lineup doesn't tell you who left you the present, and therefore you can't enforce, okay? If you can't prove it, you can't enforce it. Don't forget, if you're on Kiowa Communities, losing party pays. One of your duties as a board member is fiscal responsibility. If you don't think you can prove your case and win in court, you don't want to pay the other side's attorney. So if you can't prove it, you shouldn't be moving forward. All right, so let's talk about fines and violations. Now, I know it's tiny print because this is HB 1137 and there's a lot there. So now we can no longer have per day fines. So we all have to make sure that your policies have been amended to remove any daily fines. And it says no foreclosure on balances that are just fines or collection costs and attorney fees that the association incurred associated with assessed fines. Why is that important? Because if you hire me to sue somebody who built a shed in that community that doesn't allow sheds and I win and I get a judgment and he decides he doesn't want to pay, you can foreclose on my judgment. Because I'm not seeking assessed fines. I'm seeking covenant enforcement. So you can still foreclose after you get the covenant enforcement judgment. All right? So, if in fact you have a violation that threatens public safety, health, or welfare, you can send a 3-day notice. Let's think about what actually in covenant enforcement is going to be something that's going to be in public safety, health, or welfare. Okay? Maybe a leaky pipe, if you're in a condo or a townhome. Maybe if you have a homeowner who has a dog that has just bitten another neighbor, public safety, we're gonna send a 3-day notice, okay? Maybe if in fact you are in a townhome and you have found out one of the neighbors is hoarding. Why is that safety? Because it's a fire hazard. And you're gonna get a fire marshal involved to prove your case. But we don't have a lot of health and safety issues for most of our single-family homes. And so if you have a single-family home community, other than the dog bite, you're probably not going to have very many 3-day violations. All right? Most of your violations are going to fall under the second provision, which is written notice by certified mail, 30 days to cure, or you can turn it over to counsel. After the first 30 days, if they don't fix it, you can fine them. Okay? Most of your violations are going to fall under that requirement. Total amount of fines can't exceed $500. It says once cured.
That $500, is that per calendar year or forever?
Awesome question, and I wish the legislature had enough brain cells to think ahead and answer that, but they didn't. It says per violation. That's all I got. Per violation.
I need more.
So do I. I'd like more. I'd like to, get them to come, like live a day in my life and look at some of the things that they've left us with because we have a mess. But for now, we don't know that answer. Once cured, you have to send a letter that says it's been cured. You have to tell them how many fines you have imposed at that point. The fine policy that you draft has to tell them what intervals that the fines can be levied. And your hearings on the covenant enforcement now, this is a change, have to be in executive session. Okay, so where does that leave us? When you look at this language, this is the language of HB 1137, we can't enforce dog barking anymore. We can't enforce not picking up after a dog. We can't enforce weeds. Because it says in the verbiage that you shall provide the unit owner written notice of the violation, and they have 30 days to cure it. 30 days to pick up the poop, 30 days to pull the weed, 30 days to stop the barking. Now, if any one of you communities would like to be a test case, come see me. I will be happy to take it to court to try and explain to the court that this is insane and that there's no way that this can legally gut all of your covenants, but realistically, there's a big likelihood we'll lose. Now, I have a few communities that are trying to build the case on like parking, because the owner's not allowed to park in the driveway. And to get around the 30-day cure, they park a different vehicle in the driveway every night. And I said, yeah, but it's the same violation, it's still parking. Come on, somebody be bold, let's go take this to court. Get me 30 photos on game. I haven't had a taker yet, but I'd like to. But realistically, because it's 30 days to cure, what you're left with enforcing are things like painting the wrong color, failing to paint, failing to mow for 30 days, failing to do the same action for 30 days, okay? Our hands are kind of tied, folks. Until they get in there and clean this up, all of those things that we used to take for granted of sending them violation notices for dog barking, for not picking up, for dog off leash, you're gonna have to refer those all out because you can't help anymore. And maybe that's a win. Maybe now we just tell our city governments, guys, it's all you now, because we can't help. Right now, we're stuck using our external resources, okay? So you need to get on speed dial and find out all these different people's names and numbers, especially animal control, because that's one that you can't even touch anymore. So when we look at the external resources, you have to look at the health department. Why do I have health department? That's reporting situations. I also have situations where I have individuals who are living in the unit who might not mentally be fully there, and because they're not mentally fully there, they're causing difficulties. I had a gentleman who thought there were aliens in the walls, and so he would take a baseball bat, hit the walls all the time. Obviously, it was obnoxious to all of the owners around him, so sometimes health department becomes important. Building zoning is always useful and helpful. A lot of the counties are much more helpful to HOAs. A lot of them will actually require that as part of the submission process to get your permits, that they will require that there's a box that you check that says I got HOA approval. A lot of them have put that on their forms to try and help you. So do become, if you don't know the locals, talk to them and try and encourage them to do that, because it does help you in court, because those forms have to be signed. And when someone signs it and lies on it, it's really awesome in court. Law enforcement's getting more annoyed, but they're your only resource right now to parking. So parking on city streets, you can no longer enforce. That lovely statute went through at the same time as 1137. It was 1314, I believe. And it said you can no longer enforce in the right of way. So if it's a public street, you can't stop people from parking, not even their RVs. You can't do anything, so that's law enforcement. Obviously, fire department becomes really helpful. They'll help you with a hoarder, because that is a fire hazard. I've had many fire marshals be very, very helpful. They might help you guys if you have some of your communities have some really narrow streets and you can no longer enforce parking on it. You might talk to the fire marshal about painting one side of it as a fire lane. Once it becomes a fire lane, it helps your cops to pull people, okay, to pull them and tow them. So if in fact you have one of those narrow city streets, one of your communities, talk to the fire marshal and he can do that for you. Building code enforcement, of course, helps, and code enforcement has, up in Fort Collins and Greeley, they both, I believe, have nuisance issues, groups that will come out. So like you've got the weeds growing and you can't get anybody to do anything. Code enforcement can help with that. So you're not waiting that 30 days. Look into code enforcement on that, because I know the locals up here had a special group for a while. And don't laugh too hard on these. We all know that nobody is going to rush and fix their violation because you're going to suspend their voting. But if you can suspend their pool use, you could get some great enforcement capabilities. Do remember, on suspension of pool use, that has to be in the declaration. That can't be a rule. It has to be in your declaration to give you authority to do it. But if you can suspend amenity use for being in violation, jump through the hoops in your covenants. Many of your covenants to do that require a hearing And make sure it's just you offer the hearing, and that way then you can go ahead and use that. I would never recommend shutting off the garbage, even if you can, because the neighbors are going to come after you for having done it, so yeah, don't do it. If you can stop their cable, that's almost better than the pool, because that means no internet. And so that's really, really effective if you have that ability. Towing is severely restricted. If you have towing, you use towing in your communities, you really want to sit down with your attorney and go through the documents. The tow bill that came out at the same time as HB 1137 was a 28-page garbage, back and forth, horrible thing to read. I can't tell you the number of times I've read that thing, and you try and dissect it and it makes no sense. It was meant to, for the most part, curtail what they saw as tow companies that were being what they thought predatory, right? And they purposely drive through your community to just tow anybody they could for the money. And so, it was a bit much. But it's not well written and it's a little difficult. So do make sure if you want to tow that you go and check with your attorney on it. It basically is kind of a 3-shot deal. Tag it twice, third time you can tow it. That's if towing's in your declaration. Utility shutoff, I get giggles from that a lot, but it's in a lot of the really, really old decks. And it's been through the courts in Colorado, and the courts have held it. And I say that with a smile, because if you really have it in your declaration and you want to use it, write your press release at the same time you write the letter to the homeowner, because the press is going to come after you if you think to shut off somebody's utilities because they're not complying. It's just really bad. Self-help used to be one of those things that we kind of avoided. Self-help is documents that say if owner fails to maintain, after 30 days notice, an HOA can come in and maintain for them and bill them for the work. And we used to say, why would you risk this? This is just really, follow your other processes, this is kind of dangerous. I got a lot more communities actually going back to self-help now because HB 1137 has tied their hands so much and they have so little other options available. It's something to consider. It still holds a fair amount of risk, guys. You're going on somebody else's property. As I told you, I used to be a district attorney. I was a district attorney when they started the Make My Day law in Colorado. The first case on Make My Day law where someone shot someone else was over dog crap. 2 neighbors fighting over it. And one of them ended up dead. So self-help is still in your documents. Be very careful. If you do choose to use it, you can try and call law enforcement. I will tell you law enforcement often won't come out unless you have a court order, but try anyway. Why not, see if you can get somebody there and, get on and off the property quickly and make sure you jump through all your hoops. One of the things you don't want to have happen is if your documents say you can do it, but you have to have this hearing and this hearing and this hearing and you miss a hearing, now you're going to pay for it and you cleaned up his yard, right? So make sure if you can do it, you can recoup the fees that you spent doing it and you didn't miss a step. So be very careful. ADR is, something that you need to keep in mind now, especially since a lot of the other options and avenues have disappeared from us. Alternative dispute resolution. There are free mediators. I think Greeley has them. Longmont City has them. I don't know if the city of Boulder has them, but multiple of the cities up here have free mediators and will work with the HOAs and will help you. If you've got 2 homeowners squabbling, driving you insane, dragging you in the middle, take them to the mediation. I know it's a pain. You guys are board members and you're already volunteering enough of your time, but if you can get the 2 neighbors to go talk to one another with the mediator and stop dragging you in, it's worth it to give up one afternoon. I've seen it be helpful and useful. You can't get to court until you've mediated. So you're going to mediate at some point anyway if you're going to go after a homeowner, right? If you're going to sue them because they built a shed where it's not allowed, court's going to make you mediate before you get a trial date. So if you can get them to mediation before you ever call the attorney, great. The problem is they have to show up. But if you can get it done, it's worth it.
How do we find them? Because I've tried to find them.
Where are you and who are you looking for? Greeley? pick up my card before you leave, and I will check my lists and email you the ones I've found. Like I said, they vary because as you know, each term everybody changes, but I'm pretty sure there's somebody in Greeley because I thought I'd used them. I know for a fact they are in Longmont, but we can certainly look. Thank you. You're all laughing. She knows I'm having a hot flash. It's okay. So arbitration, just to be really clear. Sometimes people confuse arbitration and mediation. They're very, very different, and the cost is very, very different. And it's important you know what you're agreeing to. Arbitration is Amanda and I are on opposing sides. And we hire this gentleman in the blue to make a decision for us. We're going to pay him $1,800 for a day, and he's going to make a decision which one of us is right. We don't have to agree to it, and once we hire him, that's it. His decision is it. It's not appealable. He doesn't have to use the rules of evidence. Amanda can go telling her cousin, friend, uncle saw me walk across the street, and he can accept it as valid evidence, even though it's not true. There are no rules of evidence in arbitration, and it's not appealable. Those are horrible facts. And then add to it, it's $1,800 a day. Okay, and some documents require multiple arbitrators. Okay? Arbitration is not what you want to use. Mediation is what you want to use. Mediation is Amanda and I take our dispute to this lovely lady in red, and she goes into Amanda's room and says, Amanda, you're all wrong, and tries to get Amanda to switch over to her side. Okay? And then she's going to walk into my room and go, Deb, you're all wrong, and try and get me to switch over. And when she has both Amanda and I in the middle, we'll reach an agreement. And she does it by telling both of us we're both wrong. That's what mediation is. Okay? And at any point during mediation, Amanda or I can walk out of the room. It's voluntary up to you sign the paper and make the agreement. Okay? So mediation is somebody who facilitates the two of you getting closer together. Arbitration is just switching out a paid judge. Excuse me, sorry. Okay, fine. We aren't going to get too many of these anymore, guys. Okay? So when you do, make sure you've dotted your I's and crossed your T's. You can't get to a fine until after you've done 30 days notice. Now, many of you had us draft policies for you on covenant enforcement. And if you did so, we included an extra letter that is not required by the statute. The statute talks about 2 letters. 30 days before the fine, and the second 30 days you can turn over the attorney. But the 30 days before the fine has to be certified, right? And once they cure, then you have to send another letter back to them telling them they cured. Well, most homeowners, not all, we all know this, but most homeowners will fix things long before it gets to fine. They get a notice in the mail and they fix things. So to take advantage of the fact that most people want to comply, and it's an oops, not a I'm being difficult, we recommended adding a warning letter. 10 days notice, doesn't need to be certified, and there's no requirement to send a cure letter once they fix it. Okay, why? To save you costs of all the certified letter fees, all the time of inspections, all the extra costs of paying for all the letters to your management companies. Okay, so if you haven't already drafted a policy and you're looking to create a policy, I recommend that you either call us and we'll draft one for you, or you draft one but add a warning letter. Just kind of in there before the 30-day requirement to fine. It pushes out how long it's going to take before you can get to fines. I understand that, but it also reduces all the fees that you guys as the community are having to pay for all these letters. Okay? So, if in fact you have our policy, you send a 10-day warning letter, nothing happened. Then you're going to send your second letter, which is going to be the intent to fine. They have 30 days to cure. Remember, you always have to tell them what did they do, And one of the things that you don't want to do is have, dear homeowner, you violated section 3.2, no parking, no trucks, no RVs, no boats, no da 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 da. And it lists that whole paragraph, but it never says what they did, okay? Tell them what they did. Dear Mr. Smith, get your boat out of your driveway. That violates section 3.2. You have 10 days to remove the boat from the driveway and either put it in your garage or get it out of your community, but you can't keep it in the driveway. Be specific. I had a law professor who used to call it a KISS. Keep it simple, stupid, okay? Make sure that you don't get the, hey Bob, I painted my fence, right? What did he do and how's he fix it? Make sure it's clear. When it talks about due process, the due process is giving somebody notice and an opportunity for a hearing, okay? I'm seeing that abused a lot, shock and amazement. Homeowner's game is, let me ask for a hearing. Oh, I can't make that date. Can I have this date? Can I have that date? Can I have a continuance? All I have is I need another continuance. And all of a sudden, we're 60 days down the road. We haven't even had a hearing, so we've never gotten the first fine. Okay, either there's a couple ways you can do it, but I think what I recommend that's the easiest is we hold the hearings with our board meetings. So you can make it on the next board meeting, or you can send something in writing. Or you can send someone else, but it will be at the next board meeting, okay? Do not let them try and play games about how many different meetings they're going to have, how many times they're going to try and continue it, how many times they're going to request a different date. If you routinely schedule your hearings separate from your board meeting, tell them when you schedule the meeting, if you do not appear at this date, you will need to ask for a different date in writing. If you do not do so within, 10 days, we're gonna have it on this date. Don't let them wait until the day of the hearing and then ask for continuance unless there's good cause. No, you're gonna have good cause. I mean, heaven forbid, I had a hearing continued today. Poor gentleman's wife passed away this weekend. Like, oh my God. I mean, yeah, no questions asked. Yes, it happens. We all have life. You don't want to be, but at the same time, don't let them abuse it, okay? If they ask you for an extension, tell them you need to know why, or you need it in writing, you need to know in advance, okay? Don't let them continue more than twice. If they don't make the first one, say this is it. If you can't make it, you have to send someone else. We're not continuing a third time, right? But tell them that in advance so that they know, because otherwise you'll be 60 days down the road and you'll never have had a hearing for your fine, okay? When you get to the hearing for the fine, first thing they're gonna ask is, who turned me in? Okay? Tell them. We can't hide it, folks. You cannot. Most of your policies say complaints are in writing. Hand them the complaint. You cannot hide that complaint. If you have to go to trial, they're gonna have to take the stand. You don't have to announce it, you don't have to, tell them in advance, but when you get to the hearing and they say, who made the complaint, be ready to tell them and hand them a copy of it right then. Because what you don't want to do is walk into the courtroom later on and then have them tell the judge how you hid that. You wouldn't tell them who the witness was, okay? It doesn't make you look like the person in the white hat, okay? So make sure that you're ready to announce that. Reasonableness. One of the things they're gonna try and do is ask for an extension. Yeah, I know, I need to mow my lawn. I've just been so busy at work. Can you just give me some more time? And the answer is, here's what we're gonna do. Mr. Smith, we're gonna impose the fine because you clearly are in violation, but if you have your fence mowed within 2 days, I'll waive the fine. Okay? If it's something they need to hire done, I'll give you 2 weeks, and if it's done in 2 weeks, I'll waive the fine when it's fixed. Don't ever agree to waive a fine if they haven't fixed it. You wasted the use of the fine. The whole point of the fine is to force compliance. At the same time, fines are not an income source. So if you've got compliance, waive the fine. Now, if you had to pay because your management charges you by letters that they write, and so those letters, if those fees went on their ledger for the letters that the management company paid, fine, leave those fees there. Those were hard costs to the community, but the fine is a soft cost, it is not income. Waive it if they comply. It makes no sense to hold it over their head. Remember, we're businessmen. We're not parents. We're not teaching lessons. If they're not smart enough to know the rules by now, we're not going to teach them any better, and it doesn't serve us to try and hold it over their head, okay? And collection for Amanda is already difficult enough, and fines just tick off judges. So if they fixed it, move on. As I said, be prepared to disclose the name of the complainant. Have a copy of the document. The Nonprofit Act and Kiowa say if an owner wants to see a copy of his file, he can ask for it and get a copy of it. So he's gonna see who made a complaint against him. Just be ready to hand it to him. When you have the hearing, don't get in a fight with them, okay? Remember, I used to have a boss who told me this when I was a DA and it ticked me off. But, you know, two pigs wrestling in the mud both come out muddy, guys, okay? Don't have a fight with them when he wants to argue about how you don't know what the rules say. Because you know he already is going to tell you don't know what you're talking about. When someone gets, really ugly and stupid and they're saying those statements, you go, sir, you only have 5 minutes. Is there anything else you'd like to say? Thank you for your time. We will issue you a written decision. Do not get in a fight. It doesn't help you. It doesn't serve you. It doesn't make you look better in front of anybody, okay? Make sure that you actually issue a decision. I have had board members who have spun and spun and spun and can't come to a decision. If you don't know whether or not it happened or not, then obviously it didn't. Let it go. If it happened, then issue the decision, issue the fine, move on, okay? Your document set a deadline for you to issue that decision. Make sure you meet it. What you do not want to do is walk into a courtroom and say, he can't move his boat out of the driveway, and have him say, yeah, and they can't issue a decision in 30 days.
Can the decision be to send it to legal?
No.
Okay.
The decision is, we're gonna fine you, we're not gonna fine you. So if you found it's in violation enough you wanna send it to council, then you should be issuing the fine. If your process is confusing, and I have a few documents by a consistent drafter of covenants that's really confusing and convoluted over who can appeal and what can be appealed and when it goes this way and when it goes that way. If you have documents like that, sit down with your attorney and create your checklist. Because again, you want to make sure you follow every step and you don't want them to be able to attack you. Post procedures that you can on the website, so there's no questions, there's no hidden, nothing that they can challenge. Make sure you're following Kiowa and your new procedure. Make sure your fine letters say, if you don't fix this within 30 days, you may be fined, okay? The hearing is not an appeal of a fine, it's whether or not you're going to be fined. If the wording is not correct in your letters, the courts will throw it out. So easiest way for you, the board, to get in trouble is that problem homeowner. We all have one who either likes to wordsmith everything we put on a board, on a letter, in a newsletter, anywhere, drives us absolutely insane because everything we do, he has to tell us how we're not smart enough to do anything. He's gonna drive us insane and we're gonna try and skip a step. Why? Because we don't wanna deal with him. And so he's the guy who we're of course gonna miss a step and then he's gonna go to court and he's gonna go, you missed a step, you have to throw us out, and the court's gonna throw it out, okay? When you have a problem homeowner, take a step back, either have a newbie on your board, try and help because he hasn't been attacked as much as everybody else, and he'll have less bias than everyone else, right? And then have the most experienced person look it over to make sure that you didn't miss a step, right? So if you use that kind of two people, that will help with your problem homeowner. Sympathy can get you in as much trouble as bias because you're gonna treat somebody better than somebody else. You have to be really careful with that. We have had a homeowner who had a hailstorm, we're in that season now guys, and had to have the roof replaced, and she was a widower, had just recently happened, and she replaced the roof and didn't ask for permission first. Why? Because she'd never done it before, her husband always handled that kind of thing, and she put the wrong color on, and she's in violation of the covenants. And so now I have a community that's suing like 3 other people for having the wrong color, but they haven't sued her yet. I go, no, you gotta sue her too. And they're like, but she's really nice, it was an honest error. And it's like, I don't care. You have to treat people in the same violation the same way. Sympathy cannot, if you wanna go help pay to help her fix it, great, go do a GoFundMe page to help her fix it. Go be sympathetic when you're not wearing your board hat. When you're wearing your board hat, you have to treat everybody the same. Okay, threats of suit. You have those homeowners who are gonna try and bully you by threatening to sue you. Okay, follow your process. If you're concerned, do exactly what Amanda said. I'll be happy to check that out with counsel. Shoot me an email and I'll let them look into your threats, sir. Thank you. Move on. Polite, my mother used to call it kill them with kindness. Thank you, sir. Next. Not enforcing something can get you sued. I have homeowners right now who are threatening to sue the HOA because the HOA won't sue somebody who won't maintain their yard. Why aren't they suing? Because they're pretty certain that she's got mental issues. And we're pretty concerned that once we get into the courtroom, the court's gonna throw us out because we don't think she knows what she's doing. But at the same time, we have the neighbors who are about to sue the HOA. Be aware that breach of your fiduciary duties can get you those threats of suit. And so sometimes that means sit down with the neighbor and explain. That neighbor wants the covenants to protect his property just as much as everybody else. And so you have to find a way to get past that. And his threats of suit don't mean he's the bad guy, it means he wants the covenants enforced. So you have to kind of sometimes work and find this weird out of the box. And so that might be, again, a GoFundMe page. It might be getting all the neighborhood kids together to help maintain this person's yard because she can't do it for herself, and it's affecting everybody's property values. There's different ways that you want to look at it, and you have to think about it, but not enforcing it because somebody's threatening something is generally not a good answer. Legal action. One of the things that you need to be aware of, and you always need to look at your documents, as who has authority to make that decision. You might all think it's a board, but I got a lot of documents out there that say it's the ARC. The Architectural Review Committee has the decision to sue. So it's not a slam dunk, it's not an absolute. Make sure the right person makes that vote. Just like it's maybe only the ARC has the right to determine on a pay choice. Board might want to step in and go, I don't like that answer. Too bad. Board doesn't get a vote in ARC decisions in most documents. You have to look to who can legally make that vote. And the board may not have any ability to step in and tell that ARC they don't like it. Now, in many cases, the board can kick off every ARC member because committees work at the discretion of the board. But as long as that ARC member is in the place and they're voting, it's their vote, not the board's. So you always have to look who has authority, who can take steps to enforce, and who gets to do something. Sometimes you might come to the decision, I suggest this at the very beginning, that you, the HOA, don't want to file suit because you don't have money. But you have that homeowner who's yelling at you, sue, sue, sue. Don't forget, they can sue too. Dear sir, if you'd like to sue her, go right ahead. Any homeowner can sue another homeowner to enforce the covenants. It's not restricted to just the HOA. Now, sometimes covenants say that before a homeowner can sue, they have to ask the board first. You have to look at your documents. But most documents, that homeowner has their own individual right to sue. And you can go ahead, sir, put your money where your mouth is, sue away. So I just want to tell this story. So this is about a house in California. This gentleman was building a second story onto his house. And where he was building, it wasn't allowed for him to have a second story because it was going to block the view of another owner. So the owner whose view was about to be blocked sued him after he had probably 75% of the second story up. And the court agreed with the gentleman with the view. And the court said, okay, Mr. Gentleman with the view, you're right, he can't have a second story. So the guy building had to take off all the second story. When he took it off, this is what he put as his vents. And this is part of the view the guy now has for the rest of his life. So now I want you to think about this, that even when you win you may not win. Okay? These people are still gonna be in your community. You may have won your lawsuit, but they're still here, and now they hate you because you won in court. So just remember that taking on a lawsuit, you may not really necessarily win. I put this slide in every presentation, whether it's on point or not, because this will bite you faster than any other thing that's out there. Whether you are a Kiowa community or a non-Kiowa community, there is a statute of limitations that gives you 1 year from the date of the violation to file the lawsuit. Doesn't matter if you have a hearing, doesn't matter if you have a lien, doesn't matter if you send a letter. If you don't file the lawsuit within 1 year of the violation, you cannot file it. So, when they paint that house Bronco orange, and that's not allowed, you have 1 year from the date they painted it to file suit. Doesn't care, anything in between, there are no delays. 365 days later, if you haven't filed that suit, you've lost, okay? So just know that's out there.
Does that also include like landscaping as well under that?
So the law says building restrictions, and it doesn't define building restrictions. And so what we've done is look to what the court decisions are, and we have seen installation of rocks be considered a building restriction. We've seen installation of trees be a building restriction. Definitely a fence has been considered a building restriction. Now, there is another case out there that says maintenance is a continuing violation, and so there's never a statute of limitation on failure to maintain. So if you paint it Bronco orange, 1 year from the date you do it, but if you fail to paint, you never runs, okay? I know, it's all weird. Judges are human, guys. Judges have angst and have all kinds of issues, and we never know what we're gonna walk in on. And so you have to remember that they're going to look and see if your covenant's enforcement. If you've amended, defendants may challenge it. If your rule doesn't further the purpose of the community, it might get challenged. If you don't follow your procedure, you might get challenged. If you don't get a board vote, you might get challenged. If the board isn't the one voting, but the ARC voted, you might get challenged. You have to follow your steps because the defendant is going to look at every avenue to attack everything you've done. That's it.
Sorry, another question, but, you know, you mentioned how there has no way to enforce some of these violations because of the way the statutes are made. And yet we have this obligation for covenant enforcement that we do that with original duties. So how do you respond to that?
Well, I mean, again, so I'm having a lot of board members get challenged on a lot of things right now. Like I had an individual actually pull their car over and kind of block in a manager to yell and scream at her in public for not enforcing parking restrictions. And parking restrictions she can't anymore because it's city streets. Our homeowners don't know what you can and cannot enforce, and that takes some transparency on your part of, hi, the law trumps, I can't do anything. I'm happy to give you, here's the flyer from the attorney's office, here's the new law. I can't take any further steps. Some of that is just answering with that. If they were to sue you on something that the law has prevented you from taking action, obviously you're gonna lose very quickly.
But the violations we talk about when we were dog hook is huge,
I do know that.
So it is something that you can fine for and articulate, but there's no way to really pin down when that violation occurs. Right.
Exactly, so I mean, it's not gonna be a 30-day violation. All you're gonna be able to do is turn that over to animal control.
Yeah, so that's when you start the fence.
I know, like I said, there are a lot of the rules that we have had to struggle with and try to help our community with that we are going to be dumping on the city officials because we can't do anything right now.
Trespassing, you have posted no trespassing, and you still have public trespassing on your property. Is that the responsibility of the board to enforce, or do you go to law enforcement? It's private property, obviously.
Trespassing, I always recommend call the cops.
Okay.
One of the things I think board members get dumped on a lot is you get handed things and told to deal with things that are outside your purview. And, one of the things, I've often written a lot of letters to homeowners going, dear homeowner, the board can do what's inside the four corners of the covenants. Point to me inside that four corners where you see that they have to stop your neighbor from calling you names. Tell me where it makes the board responsibility to stop everybody from being rude. Because it's not there and it's not gonna be there and you can't find it, and quit yelling at me to fix your neighbor's social issues. It's just not there. And unfortunately, I've written more letters telling people what's not a covenant violation recently than I have in years past.
Okay, we have a little bit of an issue where at our annual meeting, we elected a new president and a new secretary who actually was the violator of the problem homeowner. She is now the new secretary. The president resigned after like 6 weeks, so we don't have a president. So I don't know where that leaves us, because we truly don't have a board at this moment.
You only had 2 members?
No, we had a treasurer, but in this case, the community management company is taking over all the finding and the billing and the HOA bills each year.
So, your bylaws will tell you how to fill the vacancy by appointment. Any other thoughts? She does, so Amanda now does transactional.
You're gonna have to, so if you have an association that has a lot of members who are apathetic, it's going to be much more difficult. So the best way is for the current board or whoever you can get to volunteer to go out and speak to owners, engage if anyone is interested, because under your bylaws, you generally will have the option to appoint a member, and then you can have your election and bump somebody up into the presidency. If you can't get anyone, we've had that happen too. Technically, if you were ever challenged on it, the association would have a problem, because if you don't have a board making decisions, then you're not enforcing it. But realistically, we have a lot of associations that have apathetic members, including the one I live in. And so it's very difficult to get that membership going. But really, I think the grassroots kind of going door to door and saying, hey, we need people, can you just fill in? And usually if you appoint them, it's only gonna be for the remainder of whatever the term was, so it's shortened.
Well, and the other thing is there's some case law out there where the courts have actually acknowledged in one of the cases that it came down to one board member. And so then she started appointing, just, not, obviously there's no election, she's just appointing people to help her. And the court said, yes, that was completely appropriate because she is the board. And so she, even though it was just one person, that was supported. So there was another.
And I was just gonna say, at least I think in our bylaws, it states language, something along the lines of the actions may be authorized, taken or authorized by any individual board member. So
You have to be careful
if
with
that
that.
language
Yeah.
is in your documents, then you
You
don't have
can't
to be
leave until you
named
come up here and
president
take
to
some of
make
these
a
things, so you
decision.
don't have to haul it back. I'm sorry, you can't speak out. You have to come up here.
Come get some
Come
swag.
on, come take some swag so we don't have to haul it back. Oh, man, you suck, that's awful.
So as an aside, we did bring some things here. Please
Yes.
feel free to come up. The book is actually very informative. It's like a little cheat sheet on association laws, nonprofits, etc.